Have you ever thought about what actually happens when someone, say, leaves you their home in a will? It seems pretty simple on the surface, doesn't it?
Yeah, most people think that.
You're named in the will, maybe you're even the executor, or perhaps the surviving spouse. So naturally, you think, okay, great, I can just put it on the market, right? List it, sell it, easy.
Uh-huh. That's the common assumption.
But here's where it gets, well, really interesting and honestly kind of surprising for a lot of folks.
Definitely.
The immediate truth is the power to actually sell that home after someone passes away. It doesn't just click on automatically, not even if the will is super clear about what should happen.
Exactly. Intentions aren't quite enough in the eyes of the law.
So today on the deep dive, our mission is to really unpack that. We want to peel back the layers on the legal steps you have to take before a sale can actually go ahead.
We're going to explore those surprising nuances, yeah. Moving past just good intentions.
Right, into the nitty-gritty legal stuff that actually protects everyone involved.
And for this deep dive, we're drawing on some really valuable insights. They come from Don and Susie Karstedt's blog. It's called Rethinking Real Estate. They're based out of Lake Tapps, Washington.
Oh, okay.
Yeah, and they've got this excellent breakdown called Executing Estate Home Sales Through Probate. That's pretty much our guide for this chat.
Perfect. Okay, so let's unpack this. Let's use a scenario. Imagine someone listening, let's call her Sarah. Her Aunt Mildred just passed, left Sarah her house up in Lake Tapps. Sarah's even named as the executor in the will.
Right, a common situation.
So Sarah's thinking, okay, next week, call a realtor. But what's that very first kind of unexpected hurdle she's probably going to hit? Like, what even is an executor or personal representative, really? And what power do they have right at the start?
Well, Sarah's enthusiasm is totally understandable, but that's exactly where the first misconception often creeps in.
Okay.
An executor, or sometimes called a personal representative, that is the person legally chosen to manage the deceased person's estate, usually named in the will, like you said. Or, if there's no will, the court will appoint someone. But here's the key. Being named isn't the same thing as being authorized to act. It's sort of like, being nominated for a job. You might be the top pick, but you can't actually start signing contracts until all the official paperwork is done.
So Sarah being named in the will is just the first step. It doesn't give her the immediate green light, the legal keys to sell the house. What's the actual document or like the process she needs?
Exactly right. And this genuinely surprises a lot of people. Even if you're clearly named, even if you're the surviving spouse, you typically don't have that immediate legal power to sell property.
Wow.
In almost all cases, you first have to go through this formal legal process. It's called probate.
Probate, okay.
And through that process, you get formally appointed by the court. And what's really fundamental here is, once the court approves you, they issue a specific document.
What's it called?
It's usually called letters testamentary, if there's a valid will. Or, if there isn't a will, it's letters of administration.
Letters testamentary, okay.
These letters, that's the actual physical document that officially gives you the legal power to handle the entire estate. And crucially, to sell the home. Think of it like your official credentials, your mandate from the court.
So it's like a license to operate the estate.
Pretty much. Without it, you effectively have no legal standing to make big decisions for the estate, especially something as major as selling real estate.
That is a huge distinction. So until Sarah gets those letters physically in her hand, she's kind of in limbo. She can't even list the property, or accept an offer, or sign closing papers.
Precisely. Until those specific letters are officially issued by the court, you generally can't legally list the property, you can't accept offers, you definitely can't sign closing documents.
It doesn't matter how clear the will is.
Doesn't matter. Without that formal court-issued authority, you simply lack the power to make binding commitments for the estate. The system requires this specific document. It's there to prevent fraud, make sure assets are handled properly, and protect everyone heirs, creditors, from things going wrong. It's all about establishing clear, verifiable legal authority.
Okay, that makes a ton of sense, especially the fraud prevention part. So let's say the executor is appointed, they've got their letters. What's their main job then? It's got to be more than just sticking a for sale sign out front, right?
Oh, absolutely. It's far more involved than just making a sale.
Yeah.
Once you're appointed, you take on this really significant legally binding duty. You have to act in the best interests of the whole estate and all its heirs.
The best interests.
Yeah. And if we connect this to the bigger picture, it's not just about selling something. It's about something called fiduciary duty.
Fiduciary duty. Sounds important.
It is. It's basically the highest standard of care the law recognizes. It means the executor must make decisions only for the financial benefit of the estate, not for their own gain, not playing favorites among heirs.
So no sweetheart deals to friends or family.
Definitely not.
Oh.
They're legally required to sell the property for its fair market value. They also have to keep meticulous records of everything money in, money out. And crucially, they have to avoid any conflicts of interest or self-dealing. Breaching that trust can lead to serious trouble.
Wow. So it's like being the financial guardian for the estate itself, not just an agent for the heirs. That feels like a really critical distinction.
It is.
And why would a house in an estate need to be sold anyway? Are there common reasons besides the will just saying sell it?
Yeah, absolutely. A will might direct a sale, sure. But often, a home needs to be sold for other practical reasons.
Yeah.
Maybe to generate cash to pay off the estate's debts, things like medical bills, credit cards, taxes. Another really common one is to allow for a fair division of the value among multiple heirs. You can't exactly saw a house in half, and sometimes heirs just prefer the cash.
Right.
And then, yeah, sometimes the will does specifically say sell it, maybe to keep things simple or just because that's what the person wanted. It's all part of managing the estate properly.
Okay, so we've got our executor. They've got their letters. They understand this heavy responsibility, this fiduciary duty. Now, what about the court? Are they constantly looking over the executor's shoulder? Does the executor need court approval for every little step in the sale?
Good question. And the answer is, it depends. The level of court involvement can actually vary quite a bit. It mostly comes down to the type of probate that's being used.
Okay.
Generally, you see two main flavors, independent probate and supervised probate.
Yeah.
And which one it is really dictates how much oversight the court keeps.
Independent versus supervised. Okay, that sounds like it could make a big difference in how flexible things are, maybe how fast they move.
It's a huge difference, yeah. With independent probate, which you often get if the will allows it and things seem straightforward, no major fights expected dowing. The executor usually has a lot more flexibility.
Like what?
Like, they can often list the property, accept a fair offer, and move towards closing without having to run back to the judge for permission each time. It definitely streamlines things.
Okay.
But with supervised probate, or sometimes if the will requires it or state law demands it, maybe because there are minor kids involved or big debts or potential fights brewing, then the court keeps a much tighter grip.
How so?
In those cases, the executor might need formal court approval just to list the house. They might need court approval to accept a specific offer, sometimes even for the final sale itself.
Wow.
This raises a really important point.
Mm-hmm.
You absolutely need to understand your specific state's rules and which type of probate applies to your situation. It dictates the whole process.
It's not just red tape then.
No, not really. It's the court making sure, for instance, that the sale price is genuinely fair market value. It's about protecting the estate and the heirs from a bad deal.
That makes sense. So, bottom line, if you're unsure about the rules in your state or the type of probate, talking to a lawyer is probably the smartest move.
Always a good idea in these situations, yes.
Okay, let's shift to something super practical in any home sale. Disclosures. When you sell your own house, there's usually that big stack of papers about the roof, the plumbing, the seller disclosure statement. Does that apply when an estate sells a house?
This is a really interesting area, and our source, Don and Susie Karstedt in Washington State, they point out something specific and often surprising for that state.
Oh, yeah. What's that?
Well, here's the surprising fact from their neck of the woods. In Washington State, estates being sold by a personal representative are actually exempt from providing the standard seller disclosure statement. That's usually Form 17 there.
Whoa, really? Exempt? So if Sarah's selling Aunt Mildred's place in Washington, she doesn't have to fill out that massive form about, the foundation or the wiring or if there's lead paint?
According to the source for Washington State, that specific form, Form 17, isn't required from the estate's personal representative.
That sounds like way less work and maybe less liability.
Well, yes and no. While that exemption from the specific form is true in Washington, it's really, really crucial to understand something. It does not mean the executor can just hide things or be dishonest.
Okay.
Absolutely not. Even without that form, executors, just like any seller, can still be held legally responsible if they knowingly hide known problems or give out false information about the property.
So the spirit of disclosure still matters.
Exactly. What's fascinating here is that the spirit of transparency of ethical dealing still fully applies. You don't need the form, but you still need to be honest. Remember that fiduciary duty. It extends to being honest in the sale.
So It's definitely not a license to conceal issues. The advice from the Karstedts is probably still be honest, protect everyone, right?
Precisely. The best practice, even with that exemption, is always answer buyer questions honestly. Document what you do know about the house, and be equally clear about what you don't know.
Like, there's a stain on the ceiling, I saw it, but I have no idea where it came from.
Exactly like that. If you know about a leak, you disclose it.
Right.
If you honestly have zero clue about the furnace because you never lived there, you state that clearly. It protects the estate from lawsuits later, it protects the executor's integrity, and frankly, it just makes the whole transaction smoother.
Makes sense. Okay, let's talk about timing. Selling any house takes time, offers, inspections, appraisals, closing. It all adds up. But with all these extra legal hoops for an estate sale, how much longer are we talking realistically compared to a standard sale?
Yeah, you're right to brace for a longer timeline. Probate-related home sales, they almost always move more slowly, sometimes significantly more slowly.
But why is that?
Well, if we connect it back, these aren't just typical real estate deals where you shake hands and close in 30 days. There are several specific bottlenecks.
Like what?
First, there are the court timelines themselves. Filing things, waiting for hearings, waiting for those letters testamentary we talked about. Depending on the state and how busy the courts are, just getting through probate can take anywhere from 6 months to, honestly, sometimes several years if it's complicated.
Wow, years.
It can happen. Second, there's often extra paperwork and more due diligence for the title company and escrow. They have to be absolutely sure the executor has the clear authority to sell and that there aren't any hidden liens or claims against the estate.
Right, they need to cover themselves.
Exactly. And third, there's the communication piece. You often have multiple heirs, maybe other interested parties, and coordinating with everyone, managing expectations, getting agreement. That all takes time. These factors just inevitably add weeks or months to the process.
Okay, so patience is key. Definitely a virtue here. But is there anything you can do to help speed things up a bit, or are you just stuck waiting for the system?
No, you're not entirely helpless. While some delays are just built into the legal process, you can definitely take steps to navigate it more efficiently.
Like what? That's good news.
The best thing is working with the right professionals. A knowledgeable probate attorney who really knows the ins and outs of these specific hurdles, and, crucially, a real estate agent who has actual experience with estate sales.
Not just any agent.
Preferably not.
Yeah.
An agent specializing in estate sales understands the unique marketing angles, they know what buyers expect, and they know how to work smoothly with the probate attorney to make sure all the legal boxes are checked during the sale itself. They can anticipate problems and help manage everyone's expectations. It can really make a difference.
That's really practical advice.
Cool.
Okay, one last big area. What happens when there are multiple heirs? Let's go back to Sarah. What if Aunt Mildred had, like, 5 nieces and nephews who all inherited? That sounds like it could get messy fast, different feelings about the house, different money needs. How does an executor handle that?
Yeah, that's another really common and often delicate part of the job. The executor has to manage the estate for all the heirs, remember, not just the loudest one or the one they like best.
So how do they balance that?
It requires a really balanced approach. Generally, they need to keep everyone in the loop. Regular updates on the house, offers, expenses, transparency is key.
Okay.
They have to make decisions based on the court's direction or what the will says. Let's say one heir wants to keep the house for sentimental reasons, but another desperately needs their share of the cash now. The executor's job isn't really to mediate family drama.
Right.
Their job is to follow the will and the law to get the best financial result for the estate as a whole, which often means a fair, impartial sale on the open market.
So even if the heirs are arguing, or one really digs their heels in about selling, they can't necessarily stop a legitimate sale, can they? If the executor has the authority and is following the rules.
That's generally correct, and it's a point that causes a lot of confusion. Disagreements happen, sure, and they can make things tense. But the executor's main duty is to follow the law and the will to settle the estate properly.
So the letters testamentary are powerful.
Very. Unless the executor is doing something clearly wrong, like, proven misconduct, selling the house way undervalued to their buddy, or taking money they shouldn't, the heirs usually can't just block a properly authorized sale. The executor has the legal weight to act in the estate's best interest, even if not every single heir is thrilled with every single decision. It's about fulfilling those legal duties and the deceased person's wishes.
Okay, so let's try and wrap this up. What does this all really mean for you, our listener, if you ever find yourself in this position? I think the core takeaway is pretty clear. Selling a home after someone dies is way more involved than just wanting to sell it or being named in the will.
Absolutely.
You need that legal authority. It comes through the formal probate process, specifically with those letters testamentary or letters of administration. That's the crucial piece.
It really is.
And it's not just bureaucratic hoops. It's
Yeah.
the system's way of protecting everyone, the heirs, any creditors, and making sure the estate is handled fairly, transparently, and, well, legally.
Couldn't have said it better.
Yeah.
It ensures things are done by the book.
Exactly.
And as you think about everything we've discussed today, here's maybe a final thought to chew on. Have you ever encountered a really complex legal process, maybe in your own life or in your community, that seemed super complicated on the outside, but when you looked closer, it actually turned out to hinge on a surprisingly simple, foundational idea? Kind of like how these letters testamentary are the real key that unlocks the whole estate sale process. Makes you wonder what other complex systems have a simple core like that.